Okay, I was just trying to look for it.
Oh, it has. Clearly, I'm defensive.
Good afternoon, everyone. Tuesday, June 22nd, 2021. We're here for a series of detention hearings for the 323rd Judicial District Court of the State of Texas. Tarrant County is assigned to juvenile court. I'll remind those of you who are in the audience that these hearings are being broadcast live on YouTube as a courtesy to the public and in keeping with the open court's provision of the Texas Constitution. Recording or rebroadcasting all or part of these hearings is expressly forbidden. Violation of the court's order may subject you to civil and or criminal contempt. The purpose of today's detention hearings is not to determine whether or not the child is actually engaged in delinquent conduct. That will occur at a subsequent hearing. Rather, the purpose of today's hearings is to determine whether or not probable cause exists to believe the child may have engaged in delinquent conduct. In making that determination, the law allows me to consider hearsay evidence, and I will do so in the form of police reports that have been provided to the Juvenile Probation Department and then have subsequently been forwarded to me. Again, I'm not determining whether or not your child committed a crime, just rather whether or not probable cause exists to believe that the child is engaged in delinquent conduct. If I make such a determination, I will then proceed to a determination of whether or not the child should remain in detention or be released to a parent or guardian. Again, the law requires me under the Family Code to consider 5 different statutory factors, and those will guide my decision on whether or not the child should be detained. To all the kids, you have the right to remain silent during this detention hearing You also have the right to an attorney, and I will appoint an attorney for each of you. Anything you say during these hearings cannot be used against you at an adjudication, disposition, or modification hearing. But we do have 2 prosecutors in the room, and anything you say might lead them to evidence that they could use against you. And so before you blurt anything out, I would advise you to talk that over with your attorney first, get his or her advice on whether or not you really should say it, and then make the decision. Our first case on the docket is Angel Arijo Araujo. Good afternoon, Mr. Adler.
Good afternoon, Judge.
All right. Yes, ma'am. And the court has previously found that probable cause exists to believe that the child is engaged in delinquent conduct, so I won't go into the underlying basis of his detention. He's currently level 1A as of this morning.
Yes.
All right. And he has an examination pending. Mr. Adler's set for next week, if I remember correctly.
That's correct, Judge.
All right. Angel, what does your level have to be before I can consider you for release? What is it? All right. And if it were just standing in the doorway maybe once or twice, I might not hold that against you. But when it's 6 times in the doorway, that suggests to me that you're not willing to follow the rules, that you're going to do what you want, when you want, and how you want it. And that's not the kind of kid that I want in the community. I want a kid in the community who's going to follow the rules. So at least the way it appears to me today is that you're not yet ready. All right. So let's make sure we're following the rules like we're supposed to be in the back. All right. As for today, because you're not level 1 outstanding, I'm going to order that you be detained. All right. Thank you, sir. Thank you, Mr. Adler. All right. You go by Corey. All right. Corey Bibbs. Yes, ma'am. How are you? All right. Thank you. All right. Mr. Bibbs, the court has previously found probable cause exists to believe that you've engaged in delinquent conduct sufficient to warrant your initial detention. In fact, I was the one who placed you on probation back on around, I think, March 24th with memory search for burglary of a vehicle and was it evading arrest? Or, yeah, evading arrest with a vehicle. Are those the 2?
Yes, on March 24th, very good.
Does he have a parent guardian here today? Mom, why is he not in school?
Frankly, I don't know because.
Well, you're the parent.
I
You should
know, but he
know.
was with his dad and I was in another state. So I just got back to Texas, so I'm in the process of getting him back into school and so forth. Cause that's, frankly, he can't stay with his dad.
Okay,
He's gonna be with me.
okay,
So by fall, he'll be back in school and stuff.
okay. Well, he's 3 years behind in school.
And he's gonna have to play catch up,
Yes, ma'am, and that starts now.
okay?
Okay. I'm not gonna allow him to be released until I know he's enrolled in school.
Okay,
So that's summer school. That can be either online or in person.
okay,
But for now, he's level 1A. And so that goes in your favor, all right? But when you're in the back, I know you're in school, all right? When you're at home, you're not in school. And so I need Mom to get him enrolled in school, remain level 1O, and I'll consider your release. I'm not promising your release because I want you to be making good progress in school in the back, all right? Mr. Adler, anything else I need to consider?
Judge, do you want to wait the full 14 days, or do you just want Mom to show proof he's in school and then set it for attorney requested detention hearing?
You can set it for an attorney requested detention. What's the allegation that he violated his probation?
He caught his minor.
Oh, dude, that's easy. Come on.
He was with dad, caught his minor.
Okay,
Not both of them.
okay. How long had he been on the monitor before you cut it off, was you?
Not very long.
Oh, man, killing me, man.
I mean, all I have is that he was participating actively in TCAP without any issues from April 9th to May 7th.
Alright, because you're probably just like a week or two away from getting the monitor off anyway, at least with me. Alright, Mom, get him in school. Mr. Adler,
Judge, can we find out from the mom who actually has legal guardianship over him, so the court can order whoever?
I'll let you, because we got 6 more detention
Okay.
hearings, but I'll let you explore that.
Okay,
Alright,
thank you, Judge.
alright. Corey, as for right now, I'm gonna order that you be detained because I want you in school. Alright, thank you, sir. Sorry. All right, let's start our. Your turn can be here. Yes, sir. All right.
Hey, Judge, just on an unrelated matter, I was just informed the school that came back for, yesterday.
Oh, okay. Well, still, I want him
Yes,
in school.
Yes,
He's 3 years behind. We got to fix that before we fix something else.
yes, sir.
All right, start our, the court has previously found probable cause exists to believe that you engaged in illegal conduct, so I won't go into the basis of your initial detention. Mr. Dodson, does she have a parent guardian here today?
No, Your Honor, her mother called me, said she couldn't make it, but if she was released, then they could come here.
All right. Mr. Adler, I know this is not your case, but thank you for stepping in for Mr. Paul Scargar. It's my understanding we have a plan, and that Mr. Dodson and your mom have been working together on a plan for you. And so you are also level 1 as of this morning. Good job. I'm going to order you be detained today. However, hold on. It's good news. It's good news. I'm going to authorize your release on Sunday to your mom. Does that sound like a good idea? Do you want to go with your mom on Sunday?
In background support, I say, if I was level 1, no, I should be released. I'm not doing nothing wrong. Your teacher doing English for rules. And I think you guys said earlier that once I just said this, that if you have not found guilty, you should be released. I have not done nothing wrong with this.
All right. As for today, I'm going to order you continue to be detained, but I'm going to sign a release order for you to be released to your mom on Sunday.
Sunday, I cannot be released. I'm alone with my teacher on Thursday. So how am I going to be released on Sunday?
She changed the time.
Yep.
Ma'am, sit back down.
Get the fuck out of me. Move. Not move. Move. No, move.
Okay.
No, you.
All right. We will deal with her behavior later.
No.
Maurice Johnson. Good afternoon, Ms. Taylor. How are you?
Your Honor, I'm well, thank you.
Yes, ma'am. Mr. Taylor. Oh, sorry. I'm used to this. All easily together. Why is this happening? Okay, Mr. Johnson, the court has previously found the probable cause exists to believe that you engaged in illegal conduct. So I won't go into the basis of your initial detention. Level 1-0 since the 19th. Does he have prior referrals to the department?
Yes. This is 6 referrals for a partner. He's been on probation for charity theft since November.
And Judge Terry is the one who did that, is that correct? I think so. He's got a motion to modify his schedule for next Thursday.
It was on July. Okay.
All right. So just get prepared to go in today.
It's right here. You want me to come up?
No, you can speak from right there. So, you want to ask Mom some questions?
I do. And Judge, I would like to point out that he was level 1 outstanding. I guess he dropped a level on the 18th. He was level 1 until the 17th, consistently from the moment he got here. And been leveled back up today on the 19th.
Hi, Mom.
Hi.
Do you want Maurice to come home?
I do. He's missing summer school. So, yes.
Okay, and he's enrolled?
Yes, he is. Actually, they called this morning to find out why I wasn't there last week. They keep calling every weekend status updates, and I give them the same news. He's here, and so I told him this evening I should have an answer, and I'll contact them in the morning.
Okay, and if he's released today, he could be at school tomorrow.
Correct.
Okay, any concerns for the safety of you or anyone in your home?
No, we discussed some things, and I discussed a lot with his PO. So hopefully, things get better.
I understand you've spoken with him every single day that he's been in the detention facility.
Yeah, he seems to be in good spirits. He makes me feel good driving here because he had a hearing before, and I didn't want to come because I knew, hey, you ain't learned nothing. So lately we've been talking, and I feel better. I just want him to do the things that he's telling our family he's gonna do to be responsible and not be put in this predicament again.
Okay, and you've definitely noticed a change in his demeanor since he's been in detention these last few weeks?
Yeah, over the phone I have. I just want to see how that looks at home. Yeah.
All right, I know you asking Judge Porter to release Maurice to your custody today.
Yeah.
Thank you.
2 questions, Mom. You mentioned that he's doing better. What specifically makes you think that?
Just the conversations. Normally when I try to have one-on-ones with Maurice at home, before things escalate, he don't want to hear it. He don't want to talk. And so the last time he was in custody here, we were talking on the phone, and it was kind of like going in one ear and out the other one. He still don't want to hear, like blowing me off. And so, like, I talked to my husband this morning before coming, and I said, I hope he get it this time because he's listening to me. He's listening to my husband. He's not rushing us through the conversation just to kind of say, are you going to come see me? Or are you, he's not doing that. He's kind of paying attention. And I think he realizes the mistakes he's made. I discussed, you just turned 16, right? The day or so before coming here. And now you get the chance to get out, get a little summer job, and like show me you're responsible and show me you're ready to do this. It's not so much I have issues with Maurice outside of the house, it's issues with him following orders in the home, like little chores and things. And we get into it a lot because I work from home, and I just want a better relationship. I just want him to open up more and talk to me, and I know he's kind of shut down in the area, so is his older sister, and so that's what I'm hoping that we can build from this, moving forward. Because he understands that, as you see, this is not a place you really want to be. You want to be at home with your family. You want your freedom. You want to be able to eat up everything in the pantry when you want to. And I mean, I'll take that as long as you follow orders and want to go to school and want to get ready for adulthood, but not just thinking life is a game, wake up and, you're not doing schoolwork, you're not doing nothing around the house. I just want him to know, get ready, it's a real world.
Second question. He's got a hearing next Thursday.
Well, he has one on the 30th too.
Oh, he does?
It's an Arlington hearing.
Oh, not this court though?
No.
Okay. I care about this court.
Yeah.
Okay. No offense to the Arlington court, but if I were to release him to you today, can you make sure he comes back to that hearing on Thursday?
Yeah, because y'all gonna come after me then.
That's my next thing, because if you don't, two bad things happen. First concerns you, sir. I will issue a DTA if you fail to show up. Second thing concerns your mom. I can issue a warrant for her arrest that results in her being taken to the Tarrant County Jail and held there until such time as you're back here in detention and your case is over. Do you want your mom to spend 2, 3, 6 weeks in jail? Would you put her through that? Okay. Mom, knowing that you could go to jail if he fails to show up, you still willing to take a chance on him?
Yeah, because I believe that, I mean, I know he don't want me to sit behind bars, because then he won't eat. And you see he's growing, you want to eat.
He's a 16-year-old, that's what they do. All right, do we need an EM on this?
That was the plan.
All right, let's make it so. I'm gonna authorize his release on the electronic monitor. Don't show up. Bad things happen. Here, Judge Williams. All right, thank you, Ms. Taylor.
Thank you, Your Honor. May I be excused?
Yes, ma'am. One more thing. When you was last part of this, Mr. Travis? Oh. Okay. All right. We're good. Thank you. No. This is part of the oh, yeah. Yeah. Then after this. Right. After this. Please tell me I can answer correctly this time. No. How many times am I going to butcher it? You know, you would think for a year I could get it right. I'm sorry. Mary Angeles, I always want to make it an age for some reason. I apologize. Yes. Afternoon, Mr. Shaw. How are you? All right. Mary Angeles, the court's previously found the probable cause of physically 2 big days of political conduct that you want your initial decision. You got a motion to modify schedule before me 2 weeks from today. You got back to level 1 no, let's see, 3 days ago. That's a good job. Mr. Shaw, what are your thoughts?
Judge, based on previous conversations with her mom and her mom appearing in court, for some reason, she wasn't able to make it today for work related. And so otherwise she's been here pretty much every time. She's expressed an interest in her daughter coming home. She's also previously testified that she would be able to bring it back here. That wouldn't be an issue. So you know, she just couldn't be here today, but I'm sure she would like to have a return to her, and might come back those 2 weeks from today. She's released on a bond.
Mr. Alexander, she's got a history of runaway.
Yes.
And cutting off the monitor, right?
Not so much couldn't off the monitor, but she has this break from places.
Yeah. This is where your history is catching up with you today. Because you're level 1. And like you've been level 1 several times. Right? I keep up with it. But you don't want to say anything right now. But this is where your history of running away cuts against you. And it just takes a little bit longer than 3 solid days at 1-0 to convince me that if I were to release you, you wouldn't run away again. All right. I'm not closing the door. It's just I'm not opening the door today. Does that make sense? I know it's hard. I know. I get that. But it's your history running away. I can't do it. All right. So keep up with your level 1-0 and see Okay, John Michael Stearns. Yes. Good afternoon, Mr. Daniels.
How you doing?
Great. Mr. Stearns, the court's previously found the probable cause exists, believe that you engaged in delinquent conduct, warrant your initial detention. At hearing before Judge Terry on Friday, is that correct? He has been level, he got back to level 1-0 this morning. His parent guardian.
No, Judge, his father resides in Arizona and his mom resides in Alabama.
Okay. Remind me again, who was in Texas.
He was at treatment facility.
Okay, thank you. Mr. Daniels, what are your thoughts?
Your Honor, I've talked to John and he knows that he's got a hearing on Friday. I, let him know that it wasn't legal today. So,
And this is the only referral to the department.
Sure.
Correct, correct. Don't have the parent guardian to release you to today. But we'll see how Friday goes. You'll be hearing from the Judge Terry and she'll make a decision then, all right? But keep maintaining level 1-0 for me. Will you do that? All right, thank you, sir. Thank you, Mr. Daniels. All right, Mr. Jimenez. Jimenez. Good afternoon, Mr. Sierra. How are you?
good judge over yourself?
Better than I deserve. Yes, ma'am. Ms. Ross, what brings Mr. Jimenez back to court for a second time on this offense?
Your Honor, there was an ETA that was issued back in February of this month after Mr. Jimenez cut his monitor off. So he's been on the runway since then. He turned himself in on the 21st with his dad. He appeared at GP to turn himself in on that 18th.
Okay. So he was on the run for about 3.5 months, 4 months?
Yeah.
Okay, staff here today?
Now that could be here today.
Well, Mr. Jimenez, Judge Kim took a chance on you back in February. Let you go on the EM. There, after you cut it off, and we're on the run for 3.5, 4 months. So how long do you think it would be appropriate for you to just stay in detention at level 1-0 before you rebuilt the trust that you violated with the court?
Honestly, I'm gonna answer for that, because, it's not really up to me, it's up to y'all. I made a mistake, but I gotta deal with it regardless.
Okay. Well, as for today, I'm convinced that if I were to release you today, that you would be dangerous to the public or yourself, and you would abscond from the jurisdiction of the court. So on that basis, I'm going to order that you be detained. The court has previously found that probable cause exists to believe that you've engaged in delinquent conduct. That assessment occurred back in January or February. I can't remember when this initial detention was. February?
In January.
End of January. So the court will reaffirm that previous finding and find that if I were to release you today, you cut off your monitor and abscond. All right, get to level 1-0. We'll see how things go. All right. Thank you, sir.
Yeah.
Thank you, Mr. Sierra.
Yes, Judge.
All right. The open court's provision of the Texas Constitution carries with it the presumption that the public should be allowed to witness and observe court proceedings. However, the Texas Family Code provides an exception. When a child is under the age of 14 years, there's a presumption that the child's right to privacy outweighs the public's right to participate in that hearing. No such contrary evidence has been brought forth to the court's attention today, and all remaining hearings concern children under the age of 14. Accordingly, I will close the courtroom to the general public, but I want to thank everybody who may have been watching today's detention hearings on YouTube. I'll also remind you that rebroadcasting or recording all or part of these hearings is expressly forbidden. Violation of the court's order may subject you to civil and/or criminal contempt. Otherwise, have a great rest of the day.